you'll hear about 2 defendants, only one. We're going to consider both appeals, but only one has asked for us to listen to argument, and Mr. Raines represents that client. So,
yes, thank you, Your Honor. Good morning, Your Honors, and may it please the court. My name is Mitch Raines, and I'm here on behalf of Mr. Robert Holland. As you just noted, there is a co-defendant in this case, Ms. Miracle Bailey, but I have Mr. Holland. Before I begin, I'd first just like to say I raised...
Did you request time?
Oh, I'd like 4 minutes for rebuttal. Thank you for that.
Sure.
Before I begin, I would like to say that I raised 4 issues in the brief. I only plan on discussing the Confrontation Clause issue today. If this court has questions about the other, I think, 3 issues, I'm happy to address any of those, but given the time constraints, I'm going to narrow it down. And for the benefit of the audience and anybody who's watching on YouTube, I'll give a quick background of this case. As we've discussed, there were 2 defendants in this case, Ms. Bailey and Mr. Holland. They were tried for a murder that occurred on December 8th, 2021. And the state's theory at trial was that the victim was essentially lured out into the street by Ms. Bailey, where he was then shot to death. There were no eyewitnesses to the actual shooting itself. But there was eyewitness testimony that a black Jeep or an SUV, sometimes a red car, was seen leaving the area of the shooting at a high rate of speed. Officers encountered a black Jeep traveling at a high rate of speed, initiated a pursuit that eventually came to a stop, and 4 occupants bailed out of the car and basically scattered. Only Mr. Holland was arrested within a few hundred yards of the stopped Jeep.
I think it might be interesting to our audience too to know this is a Montgomery County case.
That's true.
This is a Montgomery County case.
After Mr. Holland's arrest, there was also a firearm that was recovered. The testimony was that it was found within his flight path. There was another occupant of the vehicle that went in the same general direction, though. But that firearm, through ballistics analysis, was determined to be one of the firearms that was used in the killing. And there was also what this case really boils down to as a circumstantial case is, or the strongest link, I should say, that Mr. Holland was involved comes from the gunshot residue analysis that was performed. When he was taken into custody, an officer was called to take swabs of his person. Certain clothing items were also taken, and the testimony at trial revealed that the result of that analysis was that he had gunshot residue on his person. It's not so specific to say as whether it was his hands or his face, but it was recovered from his person, and that can't be used to say that he fired a firearm, but that's certainly one of the possibilities. He could have either fired a firearm or been in proximity to one when it was discharged. And because this case is circumstantial, that is the strongest piece of evidence that really puts a firearm essentially in Mr. Holland's hand and connects him to the killing that occurred in December of 2021. In its brief, the state has argued that this issue was waived and that we are not entitled to plain error. I'd first like to address the waiver argument. As detailed in the principal brief and also the reply, this issue was not waived. An objection was made during the testimony of Agent Anderson, who was the TBI agent called to testify about the GSR report, that the basis of her testimony was grounded in the work or the report of an Agent Davis. Agent Davis is the the agent who actually performed the analysis. Agent Anderson's testimony shows that all that she did was basically check the math to see if she reached the same conclusion based on the tests and analysis that Agent Davis had performed. There's no indication that she conducted her own independent review of anything, that she ran any tests. It was, the quote is something along the lines of, wanted to make sure that there were 2 agents who signed off on the conclusion before it was sent to the courts. So an objection was made that to her testimony, and the objection began with trial counsel saying that it was informed that the state was going to have a pinch hitter, but the counsel was not informed that Agent Anderson was strictly going to be testifying from the notes made by somebody else. That is the functional equivalent of a confrontation clause.
Is that all that was said in the objection?
There was more. I thought I had it written down here. The counsel did go on to say that they were not provided any of the notes that Agent Anderson appeared to be testifying from, but that they were given a copy of the report. And in response, the state argued that Agent Anderson could be testifying off of memory, that the notes were worked product, and that she could have reviewed it to begin with. But that still doesn't change the core challenge to the testimony that Agent Anderson is testifying essentially in the place of someone else who actually prepared the report, who actually conducted the tests and did the analysis. And that is what the Confrontation Clause is meant to strike at, that you are not supposed to have one person essentially testifying as a firewall or as a mouthpiece for the work that somebody else has done. So I think that given the guidance that we have through case law, that when addressing waiver, it's meant to be looked at from a broad approach. We're not supposed to require that there are magic words that are used. It's not a narrow view of the objection that was made.
How did the trial court rule? And what was the result of whatever objection was made?
At the time of trial, the trial court found that the notes should be excluded because they were not produced during discovery. At the motion for new trial, the trial court addressed this issue more directly from a Confrontation Clause standpoint, and found that essentially scientific evidence is sometimes required and that Agent Anderson was giving that kind of testimony so that it was permissible. Not exactly what the Confrontation Clause requires, but there was a different rationale for allowing her testimony after the motion for new
So the
trial.
notes didn't come in, but Agent Anderson was still allowed to testify from Agent Davis's report.
Yes, that's correct. The relief that was sought from trial counsel when the objection was made is the same relief that would be sought if it was just a Confrontation Clause issue, such that the request was Agent Anderson's testimony all be excluded. Again, I think that it's that the objection viewed broadly or encompassingly as case law directs us to do, there is enough here to say that the Confrontation Clause was implicated such that the issue is preserved. If the issue is preserved, or even if it's under plain error review, Mr. Holland is still entitled to relief. If the issue is going to be addressed under plenary review, I'd like to just quickly address Hutchison and the process that works there. If you have questions about that, I'm happy to try and address those. Hutchison, even following Smith versus Arizona, I think is still good law. Smith versus Arizona kind of touches on Hutchison, but I don't think that it overrules it or abrogates it. So what we have from Hutchison is essentially a two-pronged standard that says that the Confrontation Clause is implicated when one person testifies in place of another if that testimony is testimonial and if it also is hearsay. To be testimonial, we have to look at the primary purpose for the evidence. So is it relevant to a criminal prosecution? And then also, does it specifically identify one individual or a suspect? If yes to both of those questions, then it's testimonial. And the primary purpose is viewed through the lens of what a reasonable person would think the evidence would be used for. So here we have a gunshot residue analysis, which Mr. Holland is already in custody following the shooting that occurred just a few hours prior. There's no real other reason to conduct a gunshot analysis or gunshot residue analysis other than to determine if somebody had fired a firearm or was within, I think, like 9 to 50 feet is what the testimony said of when it was discharged. So it's clear that the primary, and through Agent Anderson's testimony, it's clear that the primary purpose was for court. It was for litigation. Her testimony was that she reviewed Agent Davis's his work to essentially sign off on it so that there would be two people or two lab techs who would say that this is the result before it was sent to court. And then again, it's also obvious that Mr. Holland is the only person identified or related to that. And then, is it hearsay? So is it being admitted for the truth of the matter? And there is no other purpose or reason to admit, in this case, this gunshot residue test, other than to say that Robert Holland had gunshot residue on his person and was therefore either the person who fired a firearm or was in close proximity to it when it occurred. So applying Hutchison, I think it's clear that this testimony should have been presented or was only going to be properly presentable through Agent Davis as the agent who conducted the actual test, who performed the analysis, and who reached the ultimate conclusion that gunshot residue was present. And allowing Agent Anderson to testify violated the Confrontation Clause and entitles Mr. Holland to relief. The same is also true if this court were to review this for plain error. The state has only taken issue with three of the 5 prongs for plain error relief: a clear and unequivocal rule of law, that it was tactical, and that substantial justice is not implicated. As to a clear and unequivocal rule of law, the state first argues that Agent Anderson was an independent reviewer, and that is just simply not borne out by Agent Anderson's own testimony or by the function of Agent Anderson's role in this process. She explained at trial that essentially her only function was to review Agent Davis's analysis and decide if she would reach the same conclusion. There's no indication that she performed any independent analysis, that she looked at anything under a microscope, that she ran anything through a gas spectrometer to figure out what kind of elements were present, those sorts of things. She also
Isn't this kind of similar to, though, what we see a lot with autopsies, where one doctor will testify to the cause of death on an autopsy that he or she didn't perform, just based upon another doctor's report?
And if a autopsy report, if that second reviewer or medical examiner is going to testify about that autopsy report, it's still subject to a Confrontation Clause analysis. It's not categorically permissible or excluded from that just because it's an autopsy report. And it's the same thing here. It can be possible for one expert to testify to work that another has done, so long as it's not the only basis for their opinion. And in this case, it appears that Agent Anderson's only role was to evaluate Agent Davis's work and to say whether or not she agreed with it. There are other certain caveats that can allow for someone else to testify in another expert's place if they're unavailable, and then there's a list of things to go through to make sure, again, the Confrontation Clause is not being violated in those cases. But here, to say that Agent Anderson was allowed to testify in place of Agent Davis because she was an independent reviewer is just not borne out by the record, because, again, the only thing that she was doing was essentially making sure that the math mathed.
What else should she have done?
Agent Anderson, if she had performed her own independent analysis and then compared her results to Agent Davis's, and they happened to match up or overlay, then I think that her testimony would have been appropriate. But without any indication that she performed her own analysis, that she did anything other than just look at what Agent Davis had created, I don't think that you can say that she had a proper basis to give the testimony in this case. It should have come as, if they wanted that exact report to come in, then it should have come from Agent Davis. The state also argues that there was a tactical decision on the part of trial counsel such that plain error is not supported. The Tennessee Supreme Court has said multiple times that the record needs to be pretty clear of a tactical reason by counsel to not properly preserve an issue. Here we have an objection was made to Agent Anderson's testimony, a request that all of her testimony be stricken, and there is no logical reason to not properly preserve or to not properly object to this testimony. Like I said, this was a largely circumstantial case, and the keystone piece of evidence is really this gunshot residue report. That is the closest thing that can put a firearm in Robert Holland's hand, and it's the same, presumably, firearm that was recovered close to his person and that was used in the killing. So there's no tactical advantage to be gained by allowing in this evidence or not making it the objection. And then substantial justice, I would just quickly note before I run out of time that I think the proper viewpoint of what constitutes substantial justice is whether it had an impact on the jury's determination. Not was there sufficient evidence to support a conviction, but what impact or effect did this have on the jury's determination? And again, here, I don't think it can be said that this didn't sway the jury beyond to find guilt beyond a reasonable doubt when this is the only piece of evidence that essentially puts a firearm in Robert Holland's hand. Thank you.
General Evans, who I'll also note is a Montgomery County resident.
Good morning, Your Honors. Liz Evan on behalf of the state. So my notes, we will just cover the autopsy report today. So I want to go over a little bit about what actually happened. I printed this out, her entire testimony, so that I could have it referenced in case you have any questions. But Agent Anderson got on the stand and started testifying about what Agent Davis had done, and she mentioned his name a couple of times, and 21 pages of testimony went on before there was any objection. I guess it was page 1452, where at that point, General Pugh, who is here today, by the way, said, I want to show you Agent Davis's bench notes. And it was at that point that there was an objection made to the bench notes. And yes, he did say, defense counsel said, I was informed there was going to be a pinch hitter. I was not informed that she was strictly going to be testifying from the notes made by somebody else. I was not provided. I was told about it, but I was not provided it. So the objection to her testimony and the request to strike that testimony is based on the incorrect assumption she was testifying from the bench notes. She didn't have the bench notes with her. Those didn't even come into evidence at all. And so the jury went out, there was a hearing or a discussion up at the bench about clearing out, well, yes, you received this, no, you didn't receive this, and the bench notes were excluded. So this was just not properly preserved. This was a discovery violation.
That's the only thing in the record that the objection really covers.
And it's, I would say it's about 50 pages worth of testimony, her entire testimony, and you can see that half of that testimony, there was no objection. And even if the court wants to construe that later objection as a confrontation clause objection, it's not contemporaneous to all of this other discussion about what Agent Davis had done and how this was Agent Davis's report. So it's very delayed, and this is waived. So now we move to the plain error analysis, and I know there's
Let me ask one question in that regard. Before there was an objection, was there testimony by the agent that the gunshot residue matched or was found on the defendant, and that explained to the jury, or did that come out?
Yeah, she had gone through the report at that point. I am not sure if that particular piece of testimony was before or after the objection, Your Honor.
I guess my question is, was just a bunch of preliminary testimony about her qualifications and things like that, and then there was an objection, and then the substantive evidence came out afterwards?
Right, and I understand that, but she was discussing not just her qualifications, but what exactly Agent Davis had done, what gunshot residue is, what their process is in the TBI as far as what they do, and her role in examining that evidence. The ultimate conclusion, I don't remember. I don't remember, honestly, if it was before or after. I could go back and look, but I'm not going to waste this court's time with that. So moving on to the plain error factors, we can skip this Hutchison and Smith v. Arizona entirely and go straight to substantial justice. This is not an issue that has been raised in any Tennessee court before as far as whether a GSR report is testimonial. And so rather than engaging in this long analysis of applying Hutchison and Smith to this case, the court can go straight to this is not necessary to do substantial justice. And I know my friend on the other side has made much of the fact that this gunshot residue report was somehow the linchpin of this investigation, but it absolutely was not. It was simply gravy. The linchpin of this investigation was, which he concedes, that his GPS data puts him at the scene of the murder, at the time of the murder. The GPS data puts him in the getaway car, which we later learned through Sergeant McClung's testimony he was the driver of. He fled from police in the car, he fled from police on foot, and the murder weapon was found in his flight path. Now you'll see in the video, when you watch the video, there were two people who came around the building away from, fleeing from police. One went along the building line into the dark, and Holland went straight down through the grass towards the playground. And that is where the gun was found. So he was the only one who could have dropped it there.
So the video is going to show that it was in his flight path? The video is going to show his flight path?
Yes, the video is going to show his flight path. Now, what is interesting is there was an aerial map of the Lincoln Homes area admitted as Exhibit 6, but for some reason it's not in the record, so if the court wants to supplement that and you can seek to match it up with the video, we would certainly recommend doing that so you can see where the playground is related to where his flight path was. The gunshot residue report, all it showed was that he was at some point somewhere within 50 feet of a gun firing. That's all it showed. Or that somehow there was a transfer of gunshot residue on him. And that was testified to by Agent Anderson, that all of those things could have happened. So this was simply not the linchpin that the defendant wants it to be. It was the gravy, not the meat and potatoes. And for that reason, you can find that this is not necessary for substantial justice. I do want to discuss a little bit about the standard of review that was discussed in the reply brief. So my friend on the other side quoted State v. Smith, which is a 2016 opinion from the Tennessee Supreme Court discussing harmless beyond a reasonable doubt on the plain error review. However, in 2020, our Supreme Court in State v. Vance, and I'll give you the pin site, it's 596 Southwest 3rd, 229 at page 256. This case is directly on point. It is a Sixth Amendment confrontation challenge. It is on plain error review, and notably, the Tennessee Supreme Court said, a conclusion that substantial justice requires relief would imply a significant probability that the jury would have acquitted the defendant but for the improperly admitted evidence. So the end of that is a little bit of a paraphrase, but if you go to that pin site, and I would encourage and we would ask that this court follow the State v. Vance framework here in applying the plain error review to this particular alleged constitutional violation. And so I'm going to rest on my brief as far as the other plain error factors, but if there are any other questions, we would ask this court to affirm.
Mr. Raines, your rebuttal.
Thank you, Your Honor. I would first just say that I think that an objection made during the course of Agent Anderson's testimony that specifically denotes that there is a problem with her testifying to someone else's product, to an analysis that she did not perform, whether it be based on the notes or whatever, can be contemporaneous, and that the issue was not waived, that there was a proper objection that was made. If this court finds otherwise, plain error relief, again, is still warranted. It sounds like the state is now only challenging substantial justice, so I'll stick to that point. Again, I appreciate the recitation of the facts, but substantial justice is not rooted in, is there sufficient evidence to support a conviction? It is what impact did the presumably erroneous evidence have on the jury's determination. Here, I don't know if State versus Vance, if the case there was an entirely circumstantial case, is what we have here. But we do have a circumstantial case here. There are no eyewitnesses that say that Robert Holland is the individual that shot the victim. There is nothing to say that he had the gun in his hand. Judge Ayers, as you noted, 2 individuals bailed out of the car, and they both took the same general path. We don't know the exact location where the firearm was found. It was recovered before any, I want to say triangulation, but I don't know what the term is, which was kind of outside of the norm for something like that. But we do know there's a general location where the firearm was found, and it's testified that that's along Robert Holland's flight path. But again, the most crucial evidence in this case comes from the gunshot residue analysis, where Agent Anderson testified that gunshot residue cannot say if a gun was in someone's hand, but that it can say that they were in a close proximity to when a firearm was either fired, or that they are the individual who shot who shot the gun or used the gun. And that evidence most certainly had an impact in a purely circumstantial case upon the jury's determination in finding guilt. And that is the standard for substantial justice, not that there is sufficient evidence to support a conviction without it.
I assume the jury was charged with criminal responsibility.
Yes, Your Honor.
And so whether he had the gun in his hand or not is not critical to the conviction. Is that correct?
It is, because there was no other individual who was identified as a shooter. Gunshot residue analysis was performed on Miracle Bailey, but she was taken into custody, I think, about a day later. So there was no residue recovered or found on her person. So the only person who's identified as having gunshot residue on their person is Robert Holland.
But Miracle Bailey was convicted of first-degree murder too.
She was.
And so, all right.
Yeah. If there are no further questions, we would ask that this court grant relief to Mr. Holland, vacate his conviction, and remand this for a new trial. Thank you.
Thank you. Let's take about a 15-minute break if you're good
Okay.
with that.
That's good.
All right, we're going to take about a 15-minute break, so we'll be in recess until then.